welcome everybody. Welcome to the participants all over the world. We have 250 participants, or even over 250 participants, which is great. Great to have you, and also great to have you as panelists here to let us share from your experience. I will introduce you in a second, but first I would like to thank Laura for organizing this. Thank ICC Nederland for organizing this. And as Laura said, ICC is well known for its arbitration. It does lots of other things as well, but it has been or at least a very important standard for the resolution of international disputes, business disputes, and has been for many, many years. When I started as a young lawyer, as an advocate in the Netherlands, all you knew was litigation or arbitration to resolve disputes. Of course, when you had not been able to resolve them in negotiations. And mediation is something of the last years. We will hear from panelists here how different it is in countries like Australia, where Mary will tell us it's been long-standing, therefore very successful. Other countries where it's slowing down. England, where it's really beginning to catch on extremely fast. And ICC has always had the organization to administer arbitrations, and has since a while also the possibility to administer mediations. ICC Mediations, it actually has in Paris the International Center for ADR, which you compare to the arbitration section of ICC. We have Alia here who will tell us about something about that. Let the panelists in. Yes, lovely. Yes, and a warm welcome to you. We only have 1.5 hours, and if you would ask me to talk on mediation with no restriction, I would talk for 3 days in a run. We only have 1.5 hours, and for that reason, I'm very sorry that I'm not going to introduce you very long with your very interesting CVs, your resumes. If you, I'm saying to the participants, would look these distinguished panelists. If you Google them, you would see why I'm talking about the distinguished panelists. Let me start by introducing Mary. Mary, you're in Sydney, right?
I am, yes.
Hi. And I think of all those present, you're probably the mediator, among other things, with the longest experience. Can you tell us something about yourself?
Sure. I commenced mediating in 1990 with the first settlement week here with the Supreme Court in New South Wales. And, mediation was not really favourable in those days. We moved into the mid-90s and it became more institutionalised, but there was a big debate about whether it was being mandatory or not. And it is now every matter that's within courts or within a commercial arena where it's referred by government units goes to mediation. So I've been mediating thousands of disputes and all different kinds, but particularly in commercial. And I was a mortgage and credit industry ombudsman. I could tell you probably quite a lot of other things, but I also chair the Law Council of Australia's ADR committee. So we create policy in respect of ADR generally, but also the focus in Australia is very much mediation.
Thank you very much. Thank you, Mary. And a warm welcome to Eve from London, joining us from London, from CEDAR, where I trained as a mediator. That was long before, I think you were at CEDAR, but you're a mediator and you also train at CEDAR, the Centre for Effective Dispute Resolution in London. Can you tell us something about yourself and about CEDAR?
Yes, thank you so much for inviting me on the panel. Very happy to be here with you all today. Yes, so I've trained and became accredited with CEDAR, which is one of the big accreditation bodies in the UK. So as Ulrich said, it's the Centre for Effective Dispute Resolution based in London. So I became accredited in 2007. I did commercial, workplace, a number of different types of mediation. I've been mediating ever since, so close to 20 years, but I mainly focus on commercial mediations, and a lot of my mediations are international because London is the centre really for a lot of litigation cases, which therefore now encouraged to go to mediation. So yes, I'm a solicitor by background, which I know is unusual in some countries in terms of mediation, but here that's very much the expectation for commercial mediations at any rate.
Thank you very much. And you're bilingual, aren't you? So do you mediate in French as well?
Yes, I grew up in France, so yes, I do.
Yeah,
but I have to say there are less cases in France that come my way than via London.
Well, maybe our French participants will know their way to find you after this webinar. Jeremy, you are a lawyer. You are accredited in London, Geneva, and New York, I think. Isn't that right? Can you unmute, please, Jeremy? Yep.
Yes, no, I'm actually accredited in several places and trained in several countries, and it's really interesting to see how mediation varies culturally, also in the training programs. But I'm primarily an IMI mediator, an International Mediation Institute mediator. I've done trainings with CEDAR, CPR, CMAP, in Singapore, in the Netherlands. Great trainings in the Netherlands. And it's it's very different depending on where you do it. But I've been mediating since 1994, and I started off more by accident than design. The law firm I was at that did international intellectual property disputes, mainly patent and trademark disputes worldwide, was brought in by WIPO to help it at the time when it was setting up its ADR center. And I was sent to my first training in mediation as a result. I have to say I disliked it. I thought it was not serious. It was not for business. It was not for IP lawyers, serious commercial litigators. That's what I was doing at the time. I was a barrister and litigator. And then I very quickly found I was completely wrong in my very first case, where I found myself, kind of negotiating and using mediation skills. The whole solution became completely different because of a mediative approach. And so I think that is really the most interesting thing that I look forward to discussing with everyone today, which is this kind of magic that mediation can provide even in the toughest and hardest business disputes.
Yes, thank you very much, Jeremy. Well, you're not the only one, because I was trained as a lawyer and I practiced for 30 years. And when they started with mediation in the Netherlands, I laughed at it. And when I had my first experience, I became a believer, and then I became a mediator and I stopped as active as a lawyer. And everybody laughed at me and said, Neervo's gone bonkers. Why isn't he serious? Why doesn't he? But I am also totally. Thank you very much. Alia, you're joining us from Paris. Will you unmute, please, and tell us about who you are and what you do in Paris?
Hi, thank you, Bart, and hi, everyone. So yes, I am Alia Lajimi, so I work with ICC. I've been working with ICC for more than 14 years now. Before joining the Chamber of Commerce, I was a lawyer, litigation lawyer for several years, and then I joined ICC, but at the Court of Arbitration, where I managed hundreds of arbitrations in the African continent and the European, Francophone European countries. And since 2017, I joined the Center for ADR that I'm currently heading. And the Center for ADR is the unique team at ICC that is in charge of amicable dispute resolution services, including mediation.
Okay, thank you very much. We'll come to the working of that later on, how it exactly works, how you lodge a mediation with ICC Paris, etc., etc. But thank you for this. And last but not least, Marnix Leijten joining us from Amsterdam, from the law firm of De Brouw. Marnix, will you introduce yourself, please, for those who don't know you?
Yeah, thank you, Bart. I have been a lawyer, a dispute resolution lawyer for 28 years, mostly focused on arbitration, I would say, for the last 15 years. Very heavily involved in the ICC also for almost 20 years. And I must say I'm a bit of a convert. Other than Jeremy, I didn't immediately convert with respect to mediation, but that is something that occurred over the last 5 or 10 years or so. Looking very much with clients at their dispute resolution strategies and realizing that not having a good view about mediation and what it can do was not a complete set of tools to actually try and achieve that. Also because in my own experience, not only litigation but also arbitration are getting more lengthy, more costly, and very rarely lead to an outcome that either party is very happy with. So taking that on board, I've taken a mediation training. I occasionally mediate, but I'm almost reticent to say that in the company of these very experienced mediators here on the panel. But I'm discussing a lot with a lot of larger and smaller clients, basically their general dispute resolution strategies and what mediation can play a role. And I actually very frequently assist companies or businesses in mediations as counsel.
Thank you very much. You were talking about the clients, and you were talking about the dispute resolution policies, because the clients are all what we do it for. And I'm very happy finally then to have on this to introduce on this panel Ulrich Hagel, because you're the user, you're the business user that we all do this for. So, and I know we have lots of business users, or at least we have lots of people on participants who will be very interested to hear from the client side whether mediation is something to do and in what sort of cases, etc. Would you please introduce yourself, Ulrich Hagel, joining us from Berlin, I think.
Actually, I'm in Spain, but usually I'm in Berlin. That's correct. Thank you very much, Bart. And indeed, I'm in-house counsel. I'm in-house counsel for more than 26 years now. 23 years I was with Bombardier Transportation, a Canadian company headquartered out of Berlin. And 3 years ago, we were taken over by Alstom. I'm now in-house counsel at Alstom. I had the responsibility for different functions. One of them was I was the global head of litigation, which included arbitration, court litigation, but also ADR processes like adjudication, mediation, whatsoever. And besides being in-house counsel, I'm also a founding member and a board member of the Roundtable Mediation and Conflict Management of the German Industry, which is an association of about 60 to 70 companies. It's a pure users initiative. We only have companies being represented, and we are looking at all kinds of business mediation, which includes the internal or conflict resolutions. It's not only about mediation, it's about all the processes that are available. But we look at the internal conflicts and the external conflicts. Internal conflicts, a lot of workplace conflicts, but also between teams and between companies within the same enterprise. And the external ones are B2C, B2B, and B2A conflicts. And we are talking about how to resolve those conflicts. And one of the means is mediation.
Okay, thank you very much. Very interesting. Very interesting. I'm sure that very many participants will love to hear from you, more from you during this webinar. Okay, so let's kick off. First question I would like to ask to Ulrich, actually. Why mediation? What do you consider to be the key advantages of mediation?
It's a very good question. And if you talk about advantages, the question is what you compare it with. And that depends very much on the other processes you compare it with, but also it depends on the case at hand, because there is not a general advantage. It really depends on the situation. And that is very, very important. And we will come to that a couple of times probably throughout the session. I can just talk about the facts, more or less, what we have seen. We are seeing that mediation is a very quick process in resolving disputes. and that mainly compared to arbitration or court litigation, for example. By that, it is not very costly. It has a very high success rate. We are going to talk about that later on as well. It is or can be made confidential. It is very flexible, and it can be applied at all times throughout a dispute at different stages. If those are advantages, again, depends on the situation and on the comparison.
I see. So you're talking about quick resolution, you're talking about costs, and then you have a resolution. And from your experience, would you say you have a resolution, but well, it was a resolution, we might as well have accepted that, or were there actually resolutions that you say they were good resolutions and we were happy with them?
Well, we were happy with the resolutions, and that is one of the advantages of mediation, because you are really looking into the interests of the parties, and you try to enlarge the pie and bring other topics into the solution as well, and by that you make the solution more sustainable and the parties more happy with the solution. But I guess we will come to a couple of those topics later on as well.
Yes, we will. And if you can already think about, for instance, an example that you're prepared and able to share with us, that may be helpful as well when you're talking about enlarging the pie. Mary, what would you say? Why would people in Australia, I know it's the custom now, but why would they choose for mediation? And are they happy with that? What are the advantages the people you see?
Well, I'll speak from an Australian perspective, but then I'd like to talk about, because I do a lot of international panel work and policy development as well. So the comparative view that Ulrich raised, I think, is very important as to the different processes. And I'd like to just talk about one study that's quite old now in Australia, where it was made by the Civil Justice Centre, and it compared litigation, arbitration, mediation, and pretrial conferences. And the parties who are engaged with it rated pretrial conferences and mediation much higher than arbitration and litigation when they were looking at perceptions of fairness and satisfaction with the legal system and justice. And the reason it appeared that that was the case was because they understood the narrative. They felt that they were engaged in the process and they had input into the outcomes. So I think when you're looking at advantages of mediation, the potential for a negotiated outcome that better suits the needs and interests of the parties, rather than a judge's decision or an arbitrator's award, is, I think, very crucial, particularly when you look at some of the background studies. And also the need for parties, particularly in business relationships, to preserve their continuing business engagement. I did a mediation not so long ago where the parties were dealing with one particular contract, but they had 5 or 6 other contracts. So they actually needed the mediation process to work in improving their dialogue and dealing with the current situation, noting that it was probably far more profitable that they continue with their relationship and certainly with the other contracts. And I think one of the things that mediation does help with is looking at the layers of the dispute, the history. If there's a small market, they might be repeat players. And we're looking at solutions and outcomes. So one of the things I think that's very important is the mindset that the parties bring and the lawyers bring to the table. Solution, that focus of problem solving rather than the adversarial process, because it does affect behaviour. So when you're looking at advantages, obviously time, cost, flexibility of the process to adjust to the needs of the parties, reducing stress, managerial time, the confidentiality of the mediation, that it's in a private setting, and the satisfaction of the parties to look at their own outcome that they can, work with into the future that seems to be feasible. And it gives a broader perspective about outcomes and solutions rather than what might be narrow remedies that you might find in more determinative processes such as court processes. And people sort of look at mediation and say, well, maybe there's no finality. Well, there can be finality in the majority of the cases. So what we see in Australia is very high solution outcomes as far as percentages are concerned. And as I said, in courts and tribunals, the majority, if not all of the civil matters go out to mediation. But we have specialised units that are run by government agencies, such as the Office of the Small Business Commissioner in different states that deal with commercial business matters. And the success rate in those units are very, very high. So I'll probably leave it at that. There's lots to talk about, though.
Thank you very much. You were talking about the mindset of the parties and the mindset of the lawyers. I have a next question for the lawyers who are actually both also mediators, but trained as lawyers and also active as lawyers, and probably as mediation advocate as well. So if parties have negotiated, this is what you have often hear, parties have negotiated for months with the help of their lawyers and they haven't reached an agreement. So they've really done their best. So why, I mean, most people would then say, okay, we've done our best, we haven't succeeded, let's arbitrate or litigate. Jeremy, what would you say to that?
Well, I'd say first of all, there's data, there's the reality, and there's even some neuroscience behind all of this. I think most human beings, when we get involved in a negotiation, we tend to become positional. And I think most lawyers are trained to negotiate and naturally negotiate from a positional point of view, trying to convince everybody else of the correctness of one's point of view. One of the things about mediation is to kind of avoid that natural tendency of being positional, to really help people probe and understand the underlying needs and interests, because positions are almost always in conflict with one another. Needs and interests seldom are in conflict with one another. And so by opening that possibility, you really are able to get to solutions, and we'll talk about settlement rates and what a success means, but you do get, settlements in above 80% of cases in most commercial mediations. So I think that we just got to understand that it's not so much how hard or how often the lawyers have tried to negotiate. We need to understand the type of negotiation, avoiding positional negotiation. I think there's also some other dynamics to this. Let's just talk about social plasticity, this new kind of concept that is emerging in some of the research. People tend to not be very helpful to one another. There's reduced empathy, there's reduced compassion when you find yourself in kind of a team logic, us against them. When you have two people at different sides of a table, the moment the other party starts to look sad or starts to tell you a sub story, there's a tendency to kind of harden yourself and think, okay, I'm not going to fall for this. These are crocodile tears. This is emotional manipulation. We really have difficulty accepting this at the negotiation table in business contexts. Mediation actually allows much more pro-social behavior. If you look at what users want, and this is data from surveys, Global Pound Conference, CIDRA for the most recent report from Singapore, users want something more cooperative where relationships can be maintained. And mediation does allow that to happen with this different approach. I'll even just touch on neuroscience. We've just done some recent experiments in Switzerland looking at brain behavior and fMRI imaging. We actually see a different part of the brain, the nucleus accumbens, which seems to be linked to notions of optimism that actually gets engaged in mediation that is not engaged in negotiation. So you do get different even parts of the brain activated and oxygenated, which is, this is all future. We need to look into this more. It's very difficult to extrapolate, but it does explain why you tend to get higher settlement rates in mediation, even though you've already tried and failed with negotiation. One last thing, negotiations get stuck. We all know that. Mediation is all about unsticking negotiations.
Yeah. Okay. So the mindset is different from positional bargaining to try to understand the needs and the interests of the other party. So that also means that there's a change of mindset necessary when you go on from negotiation to Marnix. I'm sure you advise clients every now and then to mediate, and they say, well, why should we? Because you've already tried for us and you haven't been successful. Is that something you would agree on? That's what Jeremy says. Would you like to add anything?
Well, I'd like to briefly add that what I've started to do is reverse the question. Why not? Because what is inherent in your question actually is that if you have negotiated in a traditional way with counsel for a long time, then mediation will not add anything, because that's then that's sort of inherent in the point. So in order to bring that out explicitly, I ask people, okay, can you give me a list of reasons why you would not mediate? And that is also because I think generally the true understanding of what mediation is and isn't is still a bit lacking, or what it can be, the flexibility of it and the different environment Jeremy very much explained already. And by having the why nots piece by piece, you can often falsify them and get to a real discussion. I mean, I exaggerate slightly, but it's still with actually very good counsel in-house that people still have a bit of an idea about mediation being something where there's a very passive, purely facilitating person handing out at the right amount at the right time the big box of tissues. And sort of at the end, there's this presupposed magic where some solution turns up that no one thought about, and that happens to be something that they sort of basically in tears fall into each other's arms and say, well, we. So there's this caricature of what it is, and by asking the question in the reverse, why not, you can bring that out. That is what I've experienced and had actually quite funny conversations with.
That's interesting. Yes, the caricature, I'm sure that people will remember, will recognize that. And looking at the faces of the panelists, everybody grinned when you talked about that, because our experience, of course, as mediators, is that it is very different from the perspective that people, the non-users with no experience, have of it. Yeah. Okay, but sometimes it's escalation between the parties, right? It's really escalated, and they don't want to sit in the same room, or they don't want to. They've really tried this, started calling each other names. Mary, is that too late for mediation? What would you think?
I think it's best to give an example, perhaps, to answer this question. I just mediated a very entrenched business dispute. It was a cross-border international dispute, and the issues for me as a mediator was to keep the dialogue going, to identify any cultural impediments and recognise the history and the layers of the dispute. Interestingly, in this matter, which had a really difficult business history, which was the major issue, that was not the subject of the current dispute or the mediation. So it became apparent also that the dollars in the settlement negotiation were too narrow and off the mark, because they weren't actually talking about the real history and the issue, because it wasn't part of this court proceedings. It wasn't part of the current focus of the parties. And it was a multi-party mediation, and it was very position-based. And the negotiations were going in really different directions, and not all the issues related to all the parties simultaneously. And the messaging was aggressive, and it was very limited. And the relationships between the parties had broken down, but also between the lawyers, the communication had broken down. And so with all of this and the cultural issues and the perceived loss of face in moving, it became really positional. So with that, one of the problems was that everything that was said was misinterpreted, and the implications were also misread. And part of my job as the mediator was to start to translate what the intentions were and to try and build some trust and engage in some productive dialogue to improve the dynamics so they could actually talk about the dispute. And a lot of this was dealing with obviously sunk cost and a very bad business relationship that occurred over about a 4-year period. And when they realised that one of the parties that needed to be at the table was not part of the proceedings, the mediation was adjourned to allow them to attend and to be invited, and they chose to come. So in the end, it was like peeling an onion layer by layer, identifying the risks, looking at the best alternatives to negotiated agreements, seeing if there's a zone for potential agreement, what the risks were, and continuing to bridge the dialogue. And what happened was that it eventually settled, but everybody had to work really hard. And by that stage, the issues between the lawyers had resolved, but the issues between the parties hadn't. And look, it settled yesterday. I had lots of texts saying, great, thank you. Was it a waste of time mediating and coming back to the table? In this case, no. And it was confidential. It salvaged a capacity to be able to reach an agreement. And mediation appears passive and easy. It's not. It requires everybody to work really hard, as Ulrich has indicated and others, that everybody needs to come to the table. And this was a really good example to me that that was the case. So everybody had to be engaged to come. And I think it is worthwhile. And in some of our mediation programs, people go to mediation more than once, and the courts are ordering it sometimes more than once. So we're really down the line of development with this, and people don't try to push back on that. They actually engage with it and see opportunity. So I think, you know, it is a different experience perhaps in Australia because of the length of time and the developments that we've had, and the business community and commercial mediation is, you know, it is one of the most common other than family mediation. And I think certainly worthwhile.
Thank you very much, Mary. Now, if you and I had a dispute, if Jeremy and I had a dispute, and I'd be extremely aggressive and annoyed, and of course Jeremy will say it's all because of neuroscience, but I'm simply extremely annoyed with him, and the court has ordered me to mediate with him. So what would you do, apart from the box of tissues? What sort of questions would you ask me to get? Because you're talking about peeling the onion, etc. How would you peel that onion in my case? So I mean, really, I'm really angry.
Well, what I would do is meet with you probably beforehand, as well as with Jeremy beforehand, maybe on the day of the mediation, and ask you a few things like, well, what do you see might be a benefit in this? I want to keep your eye on the horizon for resolution, but I'd also want to work with you to understand exactly what was really making you angry, and whether you would step forward in one small step to move towards a dialogue and a discussion. So there are many strategies, but what I find is an opportunity for people to speak directly to the mediator about their issues and to vent a bit about those matters, gives them an opportunity to start thinking about why they're here, what the past was, what you're doing in the present, and to look towards the future, and to look at that risk of other alternatives, because they are often very sobering, but there are many, many different strategies which would take probably days for us to run through.
Yeah, thank you very much. Yeah, you were saying it's confidential. Could you just elaborate on that, the confidentiality?
Well, certainly in Australia, we have different means of confidentiality. So if we're looking at the basic confidentiality that might be adhered to, is that we always have the parties and everybody attending the mediation to sign a mediation agreement and at least a confidentiality agreement. But if I'm doing a very large matter involving communities or a city or, you know, Indigenous populations and mining, that cannot be confidential. But in commercial matters, invariably they all are, and you have them sign up on that. In addition to that, we have legislation, and we have referral procedures from different directions that might be covered by regulations and so forth, which is an added element of confidentiality. But there are exceptions, and they deal with criminality, you know, a whole range of, but they're quite rare, but I have had to deal with some over a 30-odd year experience. But the majority, you know, you sit down and you say to the parties, it is confidential, you know, as far as the law allows, and what we're going to be dealing with today is a dialogue within that context. Do you all agree? And there are many different ways of setting up that process. But the other thing that people need to remember is that the agreement reached at the conclusion of the mediation, if that's where it goes, needs to have terms within it that make that confidential, because that agreement is a new contract between the parties and can be utilised. So there's the confidentiality of the mediation process. And I could go through the legal issues, but I think that's probably enough for today.
Yeah, thank you. We have a question from one of the participants for Ulrich about confidentiality. You said, Ulrich, you were talking about the advantage. You said it can be made confidential. We just heard from Mary that it is usually confidential, and that's the same in Europe, etc. But in what sort of cases would parties consider that it would not need to be confidential?
Well, especially when it is in the public interest. So when you have big construction projects where a lot of different parties are involved, and it needs to be debated transparently in public, then you don't want to have confidentiality. So that might be one of the examples.
I see. Thank you very much. Thank you very much. Eve, if I would be sitting at your table as a positional bargainer, as a party, and be extremely angry at Marnix this time, not Jeremy, but Marnix. So what would you, how would you unpeel me?
Well,
or would you just simply not start? Or you simply just not even give it a try?
It might be helpful for your audience just to take a step back. I absolutely agree with everything that the panelists have said so far, but just to sort of bring it together in a little bit of a sort of process clarity for your listeners. So I mediate a lot of commercial cases. Typically the pattern is, there's a mediation agreement which the parties sign up to, and what that says is they are coming to the mediation in good faith, with a really good faith intention to try to settle the case which is otherwise likely to go to litigation or arbitration. So they come to the mediation day, and it's either online or it's in person. They come into their separate rooms, and that's their safe space. And I think it's important to emphasize that the party's private breakout room, if it's online, or the room that they're working in during the day in a conference center, that is their space, which is completely private to them. And you asked about confidentiality, there's two layers of confidentiality in mediation. So one is the whole day is confidential, and the parties can't obviously use what is said at the mediation outside of the mediation against one another. So in that sense, it's quite safe from a litigation type. It's different from litigation in that sense. But the other very important feature is it's all confidential in your room with your mediator. So the mediator, who, remember, is completely neutral in this, the mediator doesn't have a view who's right or wrong, doesn't advise, just helps and coaxes and challenges in each room to try to help the parties understand, as I think Jeremy and everyone has outlined already, it's about understanding what the interests are in the other room, being able to listen to that and be able to address that. Now, typically in my mediations, I encourage the parties to have what we call the joint session. The joint session means they come around a table, so each side has a short period of uninterrupted time to tell the other side what it is they want to achieve today. And those, I try and work with the parties ahead of time to make sure they're constructive, reasonably, the rhetoric is not too positional, that it's not just the lawyer standing up saying, we're going to beat you in court because our arguments are the stronger ones. It's more about, okay, this is why we think we'll succeed, but this is what we want to achieve. Now we're listening to you. What is it that you need? And absolutely Mary's points about if there's an ongoing relationship, then absolutely those are the kinds of future-based solutions that you're looking for. So, and then after the joint session, the parties go back to their separate rooms. The mediator typically will shuttle between the rooms. And remember, everything is without prejudice on the day, as we call it in England. So, and the power of that is no one is held to anything until it's all agreed, reduced in writing in a settlement agreement and signed by the parties. And as Mary said, that then has force of contract. So I'm really talking here just about the international or not, the commercial cases. There's, of course, much wider application for mediation, but just to sort of crystallize the opportunity of that, those two layers of confidentiality, the without prejudice safety net of the negotiations, and the fact that Mary's absolutely right. They're really tough days. They're really hard days. We do work in preparation leading up to it, which was very constructive. But on the day, it's a hard negotiation, using the mediator to shuttle between the rooms, sometimes bringing the parties together more than once, but forward focused. And there's a sort of momentum that builds during the day. Offers are made and exchanged backwards and forwards, perhaps 2-3 times, and most mediations will then result in a settlement. So I'm a very strong advocate for mediation. We can talk about the stats later on in this talk, but I think as Marnix said, why not?
You said you in the separate rooms, you have a private session with one of the parties. You try to help them understand the interests in the other room. I would add, from my experience, you sometimes, unfortunately, also have to help them understand their own interests, because they're only thinking about positions, and their lawyers are not trained to think about interests and needs only in positions. So, yeah. You also talked about when there's an ongoing relationship between parties, and that is a question. I would say, does that mean, because you often hear, well, mediation is only for parties that have an ongoing relationship and not for one stop. What would you say about that, Eve?
I mean, I do quite a lot of contentious probate, for example. So, siblings falling out over the way the father has left their estate, for example.
Yes.
And I enjoy working on those because there is always the hope that you're going to be able to bring family members back together in a more harmonious set of relationships. And that's not always the case. And I'm actually working on an ongoing case at the moment where I had hoped that would be possible, but it's not. And the parties will do a deal. It will be very creative. It will involve money, land, lots of different kinds of rights, but it's not going to involve an ongoing relationship. And same goes for businesses. Sometimes it's about understanding and agreeing how we part ways. And very importantly, we retain control as parties. I will encourage parties to remember the agreement that they reach, if they can reach an agreement, is voluntary. So it's not imposed on them by an arbitrator or a judge. It is the parties, with the help of the mediator, that find that agreement. So if it's an agreement to part ways, then be adult about it and do that on the best possible terms.
You were talking about the day of the mediation. I know that in the Netherlands, for instance, on family mediations, etc., they have mediation sessions, 2-hour session, and a week later another 2-hour session. I know that from experience that you do 1-day mediations, or that's the and that would probably go for Mary as well, and for Jeremy, or no, Jeremy, you're not somebody for the 1-day mediations.
No, I think there's a very much a cultural element here that comes into play. And even listening to Eve, I'm a CEDAR trained mediator. I work in the UK, the US as well. There is this notion that first put the parties in their separate rooms, and then kind of you have the day to work things out, with usually a mediator's proposal coming out late at the end of the day if the parties have been incapable of settling on that day. The statistics I've seen from the Netherlands, for example, people tend to work in half days, not in full days. In Switzerland, we tend to work similarly in kind of, groups of hours. And especially in complex commercial cases, you will very often discover and have new issues come to the table. So obviously preparation helps if you are going to do a 1-day mediation, but I find it very helpful, especially with Zoom and other technologies. You can chunk things down. We can have several preparatory meetings. We can still have the concept of a 1-day mediation, but much more downstream. But I still prefer to think in terms of half days for the work that I do, and spread them out. It will come to the same amount of time collectively, so it might be 2 or 3 collective days of work by the end of it, but that can be spread out over 1 or 2 months in that time frame. But I do find that more and more for complex cases, pre-meetings with the parties are very important, as well as a first joint session in a way to kind of work things out. And then when you kind of do get to that facilitated negotiation, it works much better when they've already understood their own needs and interests. They've understood what their alternatives, the BATNA, WATNA, RATNA, we can talk about the jargon later on, but all of these different things have been understood. And it also makes a huge difference when people come to the room knowing one another or having a sense of knowing one another. The big issue is, we've used the word relationship so many times in the call already today. What do we really mean by relationship? Are we talking about the relationship between the disputants and their ability to continue doing business together? Or are we talking about the quality of the discussion? I think even lawyers who do not know one another, or even who do know one another very well, can get very easily frustrated. I see the kind of breakdown in relationships that happens not just between the companies, but very often between counsel when they think the other side starts to be unreasonable. And so I think mediation is more about the quality of dialogue. It's more about this idea of let's find a cooperative tone with which we can work. It doesn't matter so much. I mean, I'd say 95% of the business cases that I mediate, people are coming to, with what I would call a divorce business mediation. They never want to see one another again. The idea of being in the same room is intolerable to them. They just want this over with. Let's pay the money. Let's settle and let's get this done with. Never have to see these people again. That's what I want. The surprising thing is how often, once they start to listen, once they start to understand that maybe it's not 100% their fault, maybe we somehow contributed to the situation, maybe we misunderstood their intentions when they actually did something because we were, judging things by what we could observe, but we didn't know what the inner thinking was at the time or what the other pressures on them were. These things make a huge difference. So whether or not that's a good thing, many of the mediations that were divorce, we will never meet again mediations turn into situations where people can continue doing business, and this is where that magic sometimes comes in. Sometimes they walk away with more business than the value of the original dispute. That does happen. I have seen that happen many times, simply because we've been able to move. And I'll just give you a final example. I just did a mediation between two pharma companies. It was very clear at the outset that two CEOs had not spoken to one another in 5 years. So the lawyers, yes, were there. There have been many court hearings. There was real frustration about positions taken where each side was, accusing the other of practically lying and falsifying evidence. But once the two CEOs were able to actually get into a meeting together and speak, even have a meal together, God forbid they should actually eat together, it made all the difference because they had such a different understanding of one another's logic, behavior, and how they felt compelled to behave in certain ways. So all I would say is we've got to understand that we're looking at the quality of the negotiation, the dialogue itself. The question of the broader relationship for me is almost a separate one. It may or may not continue, doesn't matter. The question is, how good is the quality of the dialogue?
Yeah. Okay. Great. Thank you very much. We're almost halfway through our webinar. I would like to just wait for a few minutes before we have our break to just give the participants who don't know an idea of how it works. Whether, for instance, the mediator gets to see documents beforehand. That would differ per jurisdiction, I think. But Mary, what would you say? Do you receive large bundles of documents before the mediation?
It depends. It depends on the parties often. It's become part of, I suppose, our culture, at least the court culture, to provide what's called position papers, which are really badly named. They're really sort of statements of how they see the case. But so I'm trying to change the dialogue from being position papers. But there is an agreement amongst the parties as to what they might provide to me, but obviously each of the parties can provide whatever they want on a confidential basis. But over the years, it seems to have, focused on this, at least in the court processes. But if I'm looking at the broader context, when I'm dealing with business disputes or otherwise, I might have nothing. Or they might send me a copy of an agreement, or they might send me a copy of emails. It just depends. And I think, just to recap, the timing, the issue of documents, the whole issue of the process, how, what the focus will be, to me is really working with the parties as to what that is and designing the process with the parties. And they do like to engage with that, I find, and it does make it a far more profitable enterprise as far as the mediation process is concerned and outcomes, if the parties actually engage with that. So in the preparation or even in the initial, dialogue between me and the parties, I will raise all of those issues with them to see what the expectations are. So documents, look, I could have trolleys of documents, boxes of them, in some circumstances, and in others it might be I'm mediating under a tree on a farm enterprise where they're showing me things as to what's occurring, or at a mining site. So it depends.
Yeah. Yes, I recognize what you say about the boxes. I often have mediations where the lawyers come in with suitcases as if they're going on holiday, but suitcases full of documents. And I must say, most of these cases, the suitcases remain closed, and the parties do reach an agreement, and the lawyers don't understand how. I didn't when I was a lawyer, positional bargainer, you also mentioned, I think, that a party can send you confidential information beforehand, right? Which doesn't reach the other party. That's interesting.
Well, it's like having a private session. So
I see.
It still falls within that concept. It doesn't happen as much these days as it used to, but they are entitled to if they wish.
Yeah. Okay, so mediation's on the move. It started with 0. How is the success rate, or depending, of course, on what you define by success, but let's say a full agreement. Eve, I know that CEDAR does a biannual survey for this. Do you have some? Could you tell us about this?
Yes, certainly.
survey?
So CEDAR do run a biannual audit, which they reach out to lots of law firms and mediators to sort of gather data. So it's interesting. It is a data-based audit. It's probably not everything, but it's very indicative. And so I was looking at the different audits over the last few years. The last one, the 10th audit, was published in 23 and contained data up to 22. And I was looking in 2010, there were about 6,000 mediations. I'm just talking about the English market, actually. It's the UK. So around 6,000 mediations in 2010. We're talking commercial mediations, I should be clear. This is not family or community, not much workplace. It's mainly the commercial ones. By 2022, there were 17,000 cases. So a very, threefold increase in, just over 10 years. Obviously, there's been, since COVID, a very significant emergence of online mediation, which is probably relevant for your audience, because a lot of my mediations that I carry out online may be high value, but you can have one party in Africa and one in Thailand, for example. Give or take time difference, we're all on the same platform. There's about 64% of commercial cases being conducted online. Obviously, there were many more during COVID, but what that shows is that a lot of online work continues to take place. In terms of settlement rates, according to that last audit, 72% of the commercial cases settled on the day of mediation, and another 20% shortly thereafter, which I think goes to Jeremy's point about mediations are often, an extension. They don't all just happen neatly in one day, even if the CEDAR model procedures is sort of the one-day model. So there's a total settlement rate of 92% in the UK based on recorded data for 22. This you can take with a pinch of salt, but I did see on the beginning of the webinar last week that someone was referring to that CEDAR claim that they have procured mediations which record a value of over £16 billion over the years. I don't know whether that's something that really can be quantified, but I am assuming they're just taking the value of the claims and counterclaims. So yeah, it's a significant market.
Okay. Ulrich, as a user, as a continued user, it must be at least partially successful. What would you say about your idea about success rate?
Yeah, thanks for asking that question. This question is always also raised within the company. What is the success rate? Should we do that? Does it make sense? And I'll put it the other way around. We had 2 very big mediations that failed almost at the same time. One was in the UK, one was in Germany. And at that point in time, our management was saying, well, what are you doing there? Stop that nonsense. And we said, well, wait a minute, it's just 2 cases out of I don't know how many. And let's do an analysis of all the mediations where we have participated within the last 5 years so that we have a better understanding whether this makes sense or not. And so we looked into all the mediation cases worldwide, and we came to the success rate of only 40% being settled during the mediation, and another 20% right thereafter before going into arbitration court litigation whatsoever. This is about 60%. And we thought, well, this is a pretty low success rate compared to CEDAR or all the other ones that are talking about success rates. They were much higher. And then we said, well, why were our figures so low, and what can we do to improve the success rates? And we put a program together which was called from 40 to 90. So we wanted to achieve 90% success rates. And we put a program together, and we said one of the findings was very often our people are not well aware what mediation is all about. They came with the wrong expectations to the table. They always said, well, we have to convince the mediator and so on and so forth. It was secondly the choice of the mediators. It was going with the wrong kind of claims into a mediation process, which were not suitable for mediation, and so on and so forth. So there were plenty of reasons for failure there. And we started to train our in-house people. We made a process how to select mediators. We give some further guidance on the do's and don'ts and how to prepare for mediation sessions, and so on and so forth. 5 years later, we did the same survey again, and we were at 84% success rates then. So it turned out that you can do something in order to increase the success rate yourself as a party. It is not only dependent on the mediator. Yes, the mediator is a good portion of it, but it also depends on the expectation, the trainings of the parties, and how to go into mediations, what to expect, when to go to mediations, with which cases to go to mediation, and so on and so forth. So a lot needs to be considered, and then you really have high success rates in the range of what Yves just mentioned.
It's very interesting. In combination with what you were saying about the German roundtable of, I think, general counsels. So I can imagine this is very good for companies to also to tell each other, to train your own people, to get a different mindset, because that obviously takes it. It means that you save a lot of time and a lot of money if you can settle these cases like that way. Yeah, interesting. Jeremy, I see that you wanted to add something.
No, I did, because I think what Ulrich is touching on is something that's really important to understand with mediation. I think one of the problems is we tend to think of these as kind of options. It's either arbitration or mediation. It's kind of, conciliation or something else. And I think we need to start thinking about and. If I look at the future, it's more about process design than anything else. And that's what I think Ulrich is touching on. So all I can tell you, I've probably done a fraction of the number of mediations that Mary has done, for example. I've done over 400 commercial mediations. Most of them are cross-border. And I would say that less than 5% have not settled. Now, why is that? It's not the quality of the mediator. I really don't think, yes, mediators, we are there to kind of mess things up. But if we stick to the process and we really help the parties design and think about the process they wish to have, we help them to prepare properly when they first meet. We have constructive opening presentations. Everything kind of falls into place on its own. And so I just wanted to add that we have to look into process design as part of this. So if you look at all the mediation institutions around the world, they all report somewhere between 70 to above 80% settlement rates. CEDARS is a bit different and a bit higher. It could be, yes, the quality of their training, but it could also be that there are some realities in certain common law jurisdictions where just the costs of litigation are so penalizing that there is a huge incentive to settle before trial. And many of these cases that I see in the UK or in the US, I'm asked to mediate very late in the game, much closer to trial, and it's even more difficult because by then people have had this positional mindset for much longer. So you are in a much tougher situation. But if you go to the very beginning and you do an early discussion on process design, what are the dispositive issues? Do you need to bring in evidence or experts? How can you, kind of incorporate that into the mediation process? And we start thinking of how to bring these different elements in. I think you do get actually close to 100% settlement rates. If you do a co-mediation, and I think this experiment was done in the Netherlands as well, of having an evaluative neutral and a non-evaluative neutral, a facilitative neutral working together as a team, as a co-mediation team, you've had almost 100% settlement rates because everybody gets what they want in a way. The lawyers find they have the expert they can argue with and do their discussions on the law and so on. But then you find that the business needs and interests, the underlying objectives, are really what is there at the table. Companies are not there to win lawsuits. Companies are there to bring returns to their investors and shareholders. And so when that kind of gets put back into the center of the equation, things happen. So, settlement rates are one thing, but I know that satisfaction ratings are higher than settlement rates. Again, statistics from the Netherlands, I think I saw that ACB at the time had a 76% settlement rate for commercial disputes, but the satisfaction rating was 92%. And I think we've got to think about that as well.
Yes, we had a recent study done by the Platform for Business Mediation in the Netherlands, and the success rate there was somewhere between 70, I think 74%. Just as a point, well, we had planned a break, but the discussion between you is so interesting. I think I would suggest that we skip the break because it's much too interesting, and it would be a pity now to stop this interesting discussion. To which Mary also wants to add something. Mary.
Well, I just wanted to talk about the definition of success. Way back when we were looking at all of this, whether it was in the courts or otherwise, is that it's not a scientific analysis, but what was decided was that there was a lot of productivity after the mediation and the dynamic that's created between the parties. And so a lot of the courts and tribunals started to look at a 2-month period after the mediation as to whether there would be a finality. But success can mean many things. It can mean identifying the issues, resolving many of the matters, honing the case for trial. And in Australia, we certainly look at success in a sort of broader perspective. Obviously, statistics are kept as to what might be a resolution on the day as compared to afterwards. But when I'm talking to the parties, I always say to them, look, we have a 10-day or 2-week period in which this dynamic, I think, will be quite alive for you to continue the dialogue. And I'm obviously here to assist if required. But the other thing is pegging it and anchoring it in relation to other activities that are going to happen soon after the mediation, whether it is, the fulfillment of a contract or other suppliers, or it may be something in the court's case management process of directions or whatever, seems to crystallize people's minds also. So that period after the mediation is very important, and how you just define success at the end of the day, I think is particularly important.
Yes.
And
Marnix.
if I could just
Yes,
if I could
please,
just jump
Gary.
in on that quickly, but I
Yes.
think that's really a cultural issue as well. If I
Yes.
look even at the different trainings, in German-speaking countries, they will push a joint model that you don't caucus very often, and that it's all about the quality of dialogue. So they'll use Glasel's escalation scale as a metric. Where are you? How do you bring back dialogue? And mediation is seen as a social process to get people talking to one another, because that's what it's all about. When you're doing trainings in the US, if you even think about the title of the book, Getting to Yes, it's kind of, did you get a deal done or not? That is the primary metric for some people of was it successful or not. If you look in France to the Francophone world, the training book is Futax Wheel. Everybody looks at this process, very Cartesian logic. It's a process, there are 4 different steps in the wheel. Did you or did you not do the 4 steps? That's a successful mediation, whether it's settled or not, whether you had a good dialogue or not. And so I think, you've got to kind of understand what the cultural underpinnings are, both in the training, what the expectations are, and especially, and I think Mary can vouch for this, when you start working cross-culturally, it's really that this is part of the problem. People don't have the same understanding of mediation coming into the room. Sometimes not even between client and counsel. It's not even understood that well what they're going into. They've just have agreed to the word mediation. But even in arbitration, where there's a big difference between civil law arbitration and common law arbitration, there are greater differences and shades of gray with the word mediation. So sometimes the role of the mediator is just to align that, because success for me comes when people have had that ability to discuss it, agree on the type of process they want, and then part of the job of the mediator is in fact just to facilitate process design, and even bringing in those evaluative experts if needed from time to time that can be binding in terms of some of their findings or not. It doesn't matter. That's how I look at it, and I think especially across cultural way it should be looked at. And for the ICC, I think that's also one of the reasons why it talks about ADR more generally, mediation just being one example, because it has a whole palette, a whole range of options that it offers that I think we need to think about combining, and it's not an either or.
Yeah.
Can I just say one thing about that? When I was talking about the definition of success, I mean, obviously we were talking about statistical base, but at the end of the day, it's the parties. The process is for the parties, and it's for them to determine really whether it was successful or not in their terms and in their context.
Yes, yeah. For those participants who are not aware of this different styles of mediation, Jeremy, could you just shortly explain the difference between evaluative and facilitative mediation or mediators? You just mentioned
Look,
it briefly.
even that has shades, but look, I think there are three main ways of doing it. Very often you talk about evaluative mediation. The idea is that the evaluative mediator is an expert. It's an expert who comes in, who can do reality testing and caucus, who can really probe the strengths and weaknesses of your case and help you kind of to understand what the zone of compromise ought to be. And these sorts of mediators are very willing, if not sometimes even too willing, to make a proposal and say, here's where I think you should settle. But it's basically an exercise around what is called the ZOPA, the zone of possible agreement, based on the application of norms. And then because they are an expert, they know the case law, they know the jurisprudence, they know the industry, they can make recommendations of what they think is kind of a safe or good zone in which to focus the conversations and to settle.
That's a very evaluative mediator.
Well, not it's all shades. So you can have a very soft evaluative where they're asking questions the whole time, not providing their own views. But sometimes even asking the question, on the zone of damages or whatever there is, can in itself shape the conversation. So some are more blunt and some are softer in their evaluative approaches. For me, a purely facilitative mediator is someone who comes across and says, look, you have procedural choices, you have substantive choices. I'm never going to give you my point of view. I'm here to simply help you understand your needs and interests among yourselves. Let's create, they don't have to have a guitar. They don't need a fireplace. There's no kumbaya experience, but it's more that ability to help the parties understand and listen to what are the actual needs and interests looking to the future. Norms may be helpful as a benchmark, but they don't shape the outcome. So your ZOPA, your zone of possible agreement, is not limited by norms. It's just got a much broader thing. For me, that's one of the big differences between an evaluative mediator, which sometimes is useful if you have a one-day concept, but if you remove the boundaries of time, I find that you are able to be facilitative for longer. Let's put it that way. You also have a transformative style of mediation. For me, the transformative is where people are saying, look, yes, we can be evaluative, we can be facilitative, but it's really about the relationship. How do we help people work without us? How do we get that dialogue coming so that people learn from this dispute not only how to resolve it, but have a better way of resolving their future disputes? How do we empower them to feel kind of there's more agency here, that they can take over the process themselves without the help of neutral? That works extremely well as well. So I'd say they're horses for courses. I think most sophisticated mediators these days are comfortable with a range of skills. They can be, facilitative at 9 o'clock in the morning and more evaluative at 2 o'clock in the morning, depending if it's how long the day has been. But I think it's also you need to shape and reconstruct that dialogue with the parties. I've had parties have started with one kind of mediation being required, and as things have come to the forefront, they've wanted to change it, even to a transformative type of process, when they realized they could and needed to continue working together. So I'd say we got to be flexible with that, but that's kind of stereotyping the three main different forms: the evaluative, the facilitative, and the transformative.
Okay, thank you very much. Thank you. Marnix, you'd like to add something to the discussion?
Yeah, I'd have like two very brief points. The success rates are very high, and not only on the European continent, where there are, relatively speaking, much less business-to-business mediations than I would say in the common law world. But I'd also like to basically make a bit of a controversial statement around success rate in terms of settlement rate. There are some litigation lawyers that say, I win all my cases. If someone says that, I go like, well, either you're the most brilliant litigator in the world, or perhaps you're not taking the hard ones. I wouldn't say that explains the success rate of mediations, but it's very important, and I've experienced that myself, to see what needs and what purpose a mediation can actually serve, even if it does not lead to a settlement. I've seen basically situations where, given the relatively low cost and quickness, it didn't work in terms of getting to a settlement. But the litigation or arbitration coming thereafter was much more structured. I would say less pestered by the noise of aggression and focused on the things that really mattered. And I think that's not exceptional. If you understand the process you're going through, you come out of a mediation, whether with a settlement or not, you come out of a mediation and parties come out of a mediation with a different view on what happened, what got them to where they are, and what the dispute is really about than what happened before. So I would suggest that even if you know beforehand it's not going to settle, in my view, it's still worthwhile, the cost and the time. And that's another proposition which is, I think, underappreciated, but I think it's true. And that's why mediating in the middle of a litigation very often has the same types of effects, even if it's not going to settle. And Alia may have also quite some experience in this regard.
Alia,
Yes.
we haven't heard from you much yet, but we're going to, because you're the key person in Paris for ICC mediation. Please go ahead.
Well, I agree with what Marnik just said. And I like the example when he mentioned the lawyer who won all the cases, and he said probably he doesn't have the most complicated ones, because I can assure you that at the Center for ADR and at ICC, the cases we see are not the easiest ones. They are based on multiple contracts with multiple parties at stake, and they are very technical, very often. Even the profile of the mediator they are suggesting is an expert, is not a generalist. So it's true that our success rate is not that high. I mean, it's not as high as it's not 80%. It's more than half of our cases that settle. But because these cases, well, the average amount in dispute of our cases is $10 million. So you can imagine how complicated they are, and also how technical they are, because they are in the commercial, like let's say in the construction sector. Many cases are in the construction sector. Also very complicated and technical, like let's say equipment, very technical equipment that is tailor-made equipment that is very complicated disputes. But again, I think the success is not measured only by the settlement. I've seen cases where amounts in dispute, or like the claims at the stage of the mediation, were very high, and then when they end up, they don't settle at the stage of mediation, but when they end up in arbitration, the amounts requested by the parties are reduced drastically. So I'm not saying that is certainly 100% thanks to the mediation, but I think that the mediation has something to do in that.
Oh, thank you. Thank you. We have a question from one of the participants about the appetite for parties and lawyers for mediation in case of very large claims. The question is when they are, for instance, higher than 20 million. And has there been any research done in that respect? I'm not aware of any research done, but so we can only talk from personal experience. Jeremy.
So I've been looking a bit into this. Intellectual property disputes, which is the area I come from, tend to be high value disputes. And I don't think there's any difference is the answer. I think, so first of all, it depends on the risk of non-settlement, and also the risks of going on to trial. The more complex a case, I think the harder it is to determine the likely outcome. In intellectual property cases, in your best of cases, I don't think you can give parties much more than a 60, maybe a 65% chance of winning, and that's in the best of cases. And so you have a huge risk of not winning just because of the complexity of the matter, because things can come up and undermine everything. I've certainly done cases in the hundreds of millions, and the settlement rates for me are exactly the same. They are no different. I've had cases where one party has offered 100,000, the other party was asking for a minimum of 250 million, and they've settled. And they settle not even within the 0 to 250 million, but above 250 million, because new books of business become available, new opportunities come out there. And so it has happened to me to have cases in the hundreds of millions where the settlement has actually been a book of business worth billions. And that's those magic cases that we talk about. Yes, they're not in every case, but I don't think that the amount makes any difference. It just leaves more, I think, the complexity of who's in the room. You tend to have more people, the higher the value of the case, and that is sometimes a problem. When you start having 50 to 60 people around a table, and you know that it's only really 4 or 5 key people that need to be speaking to one another, there's the social plasticity problem of how do you get these 5 people together to really talk together, connect, and be able to find a pragmatic solution. I'd say that's sometimes the toughest job of the mediator, is just getting the right people to be able to speak to one another, notwithstanding everybody else in the room who has an important role to play, but sometimes it just doesn't help. And so there's that very delicate issue of, everybody's got a key role in the process. Some knowledge is key. Some people have that knowledge. But at the end of the day, the fundamental needs and interests and understanding what the future could mean, you really need these business-minded principles, PALS, not PLS, PLES, when I say principles, main people who can really just sit there and kind of stay focused on what really matters.
Okay, thank you. Ulrich, what can you add to this?
Yeah. Well, first of all, I agree to most what Jeremy said. To me, it's not completely independent of the amount at stake. If you do have a claim of €1,000, it doesn't make sense to go to mediation, because the cost of the mediator and the mediation is higher than the dispute amount. At the end of the day, you better pay off the 1,000 or fight it at court if it's a matter of principle. But after a certain threshold, it doesn't make a big difference. To the opposite, the higher the amount at stake, you can forget about the cost of the mediation, which is not the case regarding cost of arbitration, because they are often linked to the amount in dispute. Not everywhere, but very often. That is often independent or different for mediations. There you have fixed costs for the mediators by hour, by day, by whatever you might have there. Sometimes you have it linked to the value, but seldomly. So what we have also seen in most of our cases are at least 2-digit million cases, sometimes 3-digit million cases, and it works out perfectly fine. And what is the benefit for the parties is, we usually need certainty regarding the result, because we have to put it into our books somehow. We have to make a risk provision or book an opportunity. It depends on which side we are. We have to fight those each and every quarter with our auditors there, and we want to have certainty. And going to mediation helps to get that certainty within a very short period of time, getting rid of all that stuff. So that also is a plus.
Okay, thank you. So parties have a dispute and they agree to mediate, but they can also do that, of course, before they have the dispute. Like they put an arbitration clause. The ICC arbitration clause is very well known in the world and has been for years and years and years, and nobody really has to think about it. Parties negotiating a contract say, and let's do the ICC arbitration, and everybody says yes because they know its quality is without discussion. But Alia, we also nowadays have ICC mediation clause. Could you say something about the ICC mediation clause, or the 2-step mediation arbitration clause, which I think everybody can find on the ICC website?
Well, there are model clauses indeed that are included in our rules. So the different types of clauses that are, the first ones are more like an optional mediation. That is a reminder to the parties that mediation actually exists, probably at the stage of the drafting of the contract. They don't want to commit to mediation, but it's just a reminder that mediation is a possibility as a mechanism to resolve their dispute. Or there are model clauses that are really obligations to refer the dispute to mediation, either in parallel with arbitration. So it's we see it from time to time, parties coming from in arbitration and started a mediation in parallel, so keeping both proceedings going at the same time. I would say the most used clause that we see the most in our cases is the first a period of mediation, where the parties will try to settle a dispute through mediation, and if they fail or they don't settle all of their claims, they could start an arbitration after a fixed time limit. And this is the type of this model clause D, that is in our rules, and it's the one that we see the most in our cases.
Okay. Interesting, especially nowadays for law firms that have different departments on the making of the contracts, and the others are litigation arbitration departments. I spoke the other day to somebody in an arbitration team in one of the major law firms here in the Netherlands. I said, what do the drafters, the contract people do? And they say, well, they come to us when they have a question about dispute resolution. We give them a clause. So I said, do you give them the mediation arbitration clause? Not yet, he said. That is, of course, something for people to decide, people drafting contracts. So then we're drawing somewhere near the end. Alia, again for you. So I'm a general counsel. I have listened to everybody's advice here, and I've included a mediation arbitration clause in the contract. And I have a dispute, and we have not been able to resolve it and done our utmost. So ICC mediation. So how does that go? What do I do?
Well,
and what do you do then?
You contact us.
Yeah.
So I understand that you have a clause, but not in all the situation. The parties have an obligation in their contract to refer their dispute to mediation.
Yes.
So if this clause is an obligation to have a mediation under the mediation rules, then the requesting party would file a request for mediation. They can do it by using our request for mediation form that we have, and it's available on demand. And we would notify this request to the other side, knowing that in mediation it happens often that we have a joint request coming from the requesting party and the responding party put together, like they're not responding and requesting, they're both just parties, which never happens in arbitration, for example, no. Or in other mechanisms. So we would notify this request to the other side, and we would gather all procedural information from the parties regarding, for example, the place of mediation, the language of mediation, the time limit of mediation, which is very important in this procedure, and as well as suggestions regarding the profile of the mediator. And very often, as I told you earlier, like the profile described is very technical, very specialized in our cases. So we would confirm the mediator if the mediator is chosen by the parties. We could also suggest a list of candidates from which the parties could choose their mediator or rank the mediators they prefer. Or we could directly appoint a mediator upon a proposal of a national committee, for example, or just directly from our open database. And then we will follow the whole case. We will monitor the financial aspect. We will monitor the time limit, again, which is very important in mediation. And we will review the documents, the procedural documents that are exchanged and submitted in the mediation, and address any issue if there is a problem with the objections to the mediator or so on. So this is when it's the whole process. If there is no prior agreement of the parties in the contract, or there is a clause that is not really an obligation to refer the dispute to mediation, but rather a reminder, as I mentioned earlier, then it's more the requesting party will offer mediation to the responding party. So it through the center. So the whole thing is that the center will participate in forming this agreement to mediate, because we cannot act if we don't have a parties agreement. So in this specific situation, when there is no prior agreement of the parties in the contract, we will grant the other side at least 15 days to decide whether they accept to refer their dispute to mediation, to ICC mediation. And this is a mandatory time limit. It's true that the majority of our cases are based on a prior agreement of the parties, either on a clause or in a subsequent agreement of the parties, or a joint request filed by both parties. But it happened that we have had this type of cases where there is no prior agreement. And the role of the center is very important in that sense, that we would not only notify the request to the other side, to the request to this offer to mediate to the other side, but we would also contact this other side to explain the advantages of mediation in general and how ICC mediation works. And this is very important. This step is very important. I remember in one of our cases, I contacted a lawyer who was strongly opposed to involving his client in mediation, and it was difficult to convince. And after a long discussion, he said that he would eventually try mediation. He convinced his client, and the case actually settled, thanks to a very good mediator, obviously. But I think it's really good that they tried. And we had also cases where there were no prior agreement of the parties in the contract, and in one very big case where it was based on the BIT, but the BIT didn't include an ICC mediation clause. But so this request was filed without a prior agreement of the parties, but the investor offered to the state ICC to mediate under ICC mediation rules, and the state actually accepted to have a mediation. So it could happen. It's true that the majority of our cases are based on a prior agreement of the parties, but it could happen, and it's sometimes it works. And it's just
excellent. Right. Thank you very much. We're reaching the end. I have just a few more things to say. One of them is, you mentioned the ICC mediation rules. For those of you participating in the webinar don't know about this, you can find them on the website ICC. The whole process is described there, and that's very helpful, of course, because you don't have to make up these rules yourself. They are simply there. Second remark, the investor-state mediation. I had that on my list. I just wanted to mention that is actually taking place now, and I think is upcoming. I know that Mary has some interest and experience with that. We have a question from one of the participants, which I want to address as well. That is about the enforceability of a mediation clause. If you agree to mediate and you decide you don't want to because the amount is too high or whatever, the question whether that is enforceable depends very much on the jurisdiction where you are. I know, for instance, in the Netherlands, for a very long time, the judiciary said, well, mediation is a voluntary process, So if you have agreed to mediate and you decide later on you don't want to, you may do so. But we've had a Supreme Court judgment this year saying that that has not been the case. If the mediation clause is properly drafted and as a real obligation to do so, and that's very clear, then you must indeed start mediation. Doesn't mean you have to settle, but you must at least, and that will be different in every jurisdiction. Having said all this, I think we will almost close. I have a question for those panelists who will still remain. That is one thing. I hope you could give us the silver bullet to share. Why? Well, to the participants, and then we will close. But we also have a surprise for the participants that we were going to show them during the break. We will do that at the end now. The silver bullet. Marnix, do you have a silver bullet for the participants? Can you unmute, please?
Frankly, I don't think I have silver bullets. I have the point that I started with. Why not? And falsify your why not. That is actually quite important, and you'll be quite surprised that even mediations that don't lead to a settlement, you'll look back on as having been time and money well spent.
Thank you. Eve, your silver bullet.
I just wanted to mention that when parties are reticent or don't know enough about mediation, what and I'm sure any other mediator would offer is to have a no obligation conversation with a party, just so that party can ask about what's involved on the day, how you act as a mediator, and that can be reassuring, or it can convince them not to mediate at all. But it's always out there for clients to consider.
Thank you. Mary, silver bullet.
Try it. Educate and train your people and keep them conscious of the mindset.
Yeah. Ulrich, train your people. We've heard that from you. What would further be your silver bullet?
I would have said exactly the same as Mary.
Yeah.
I would have said the same as Mary. Go for it. Try it out. Be prepared, and you will not regret it.
Yeah. Jeremy.
I would say, just to add, do it as early as possible, or consider using it as early as possible. You don't need to wait to know the strengths and weaknesses of your case. And if you use mediation early on, just to look at, it's not just what are the substantive issues, but what are the relationships possibly, or the absence of dialogue between key people? What are possibly the emotions or the egos driving this? Those are sometimes you really need to sit back and look at the full picture. You can only do that at times really early on. By the time, discoveries happen, by the time you've already spent several million to get to certain positions, and, it's very difficult to unwind and go backwards. So I would say as early as possible and revisit it constantly. Even if you had an unsuccessful mediation, think why, and it doesn't mean you shouldn't try again.
Thank you very much. Alia, silver bullet?
Yes, for in-house counsel, I would say, please participate in the mediation, attend the mediation session. Don't let your lawyers be there. And if you really think that you should be represented by an external counsel, choose a pro ADR one.
Yeah. Okay. Thank you very much. Thank you. And I have a final, a silver bullet. Finally, that is, let's train the younger ones. Let's train the next generation. Make them realize how you can resolve disputes in another way that I was trained originally. And in that respect, I'd like to mention the yearly mediation competition that is organized by ICC for students from all over the world. It's a fantastic experience where some of those present here see each other, because the students negotiate and we mediators judge them, and we mediate the cases. And I think it's for me as a mediator, it's fantastic also to see other mediators work, because it sort of you see the best practice. So that's really helpful. Now, I'd like to thank you all very much for the very interesting discussion. Laura, will you be joining us to thank the participants as well. And once again, I do hope those of you still have a few minutes, 8 minutes left after we leave, because we have a lovely cartoon to show you. If you don't know how to mediate, if you don't know what ICC mediation is, watch the cartoon and you will know.